Could a small oversight in your employment contract create a major legal headache? This week, we are joined by Jonathan Mamaril, Director and Head of Employment Law at South Geldard Lawyers, to unpack one of the most overlooked but business-critical areas of employment law, the employment contract. While contracts are designed to provide clarity and protection for both employers and employees, even small oversights in wording, outdated clauses, or poor documentation can create significant legal exposure when disputes arise. How confident are you that your employment contracts would hold up if a workplace dispute put them under the microscope? Welcome to our 2026 series, Through the HR Lens, our comprehensive market update looking at the leading HR trends impacting the Australian workforce. I am Leanne Lazarus, Recruitment Manager here at People to People Brisbane office. Let's start with the basics. When we talk about employment contracts, we are really talking about an agreement between an employer and an employee. The agreement can be written, verbal, or even implied through conduct, and it sets out the rights and obligations of both parties, things like pay, duties, hours of work, and other key employment conditions. There are a few core elements we'd expect to see in a well-drafted contract. These would include the employee's role and responsibilities, pay and benefits, which need to comply with minimum entitlements under the Fair Work Act, hours of work, leave entitlements, notice requirements or terminations, and any additional terms such as confidentiality or other protections for the business. It is also important to remember that contracts do not operate in isolation. Even if a contract is agreed between the parties, it can't provide for less than the National Employment Standards or any applicable modern awards or enterprise agreement. If it does, those minimum legal standards will always override the contract. In a very recent general protections case, the importance of having all details correct and checked in your employment contracts if there is to be protection and reduced risks. Today, we are joined by Jonathan Mamaril, Director and Head of Employment Law at South Geldard Lawyers, to talk through the case and findings, but also share some tips on how to ensure your employment contracts are up to date and comply. Welcome, Jonathan. Always good to have you back on this series of Through the HR Lens. Hope you are keeping well today.
I am having a fantastic day. It's great to be here on the Through the HR Lens again. I love this series. It's great.
So, Jonathan, I'm going to jump straight into it. Can you walk us through the case I've referenced and outline the details of the claim that was brought forward?
Well, this is a really interesting case. So the case is Lord v. Toll Transport. It's a 2026 case. Now, this is a jump protections case. Okay, so very clear jump protections, with the reverse onuses, all those types of things in the mix. So you've got a situation where you've got a senior executive been there for a long period of time. So you'd probably assume that they're more on the senior level, right? Mm-hmm. More mature. They're on a higher salary, and they're made redundant. Okay, the position's made redundant, they're made redundant, and they're given 3 months notice. Yeah, all the other entitlements, but 3 months notice. Now, what the applicant or the employee says is actually, no. The real reason that you've actually terminated my employment and made me redundant is really to cover these issues that I've made complaints about workplace bullying. Okay? Now, of course, you can read the case about the ins and outs of the general protections case. That's not necessarily the big parts of this. So what happens is the case gets filed, it goes through the process, and eventually gets to the federal court. Now, the court says no to the general protections claim. Okay, so unequivocally, and there's reasons for it, but they say no, doesn't succeed. Okay. Now, remember, there was 3 months notice provided, okay? What the applicant's lawyers argued, though, was in the alternative, the senior executive didn't get enough notice, all right? Mm-hmm. And in particular, they argued this argument of what they call reasonable notice, and that's where it becomes quite tricky. So failed general protections application, yet still gets paid over $170,000. Okay, so yeah, So we've got high salary
Yep.
employee in there for a long period of time. Challenges redundancy, but challenges on the basis of general protections.
Mm-hmm.
Fails that, but still succeeds in a notice claim.
Okay.
So the question is why?
Because as you say, the redundancy wasn't seen as it was seen as a genuine redundancy, which is obviously that part of the general protections claim that was not approved. But then the secondary has come through. So in terms of that second part of the claim that obviously has been successful, what would you say would be the key takeaways for this, from this case that HR and people leaders need to take on board and realize?
Okay, so this is where we really get to the crux of it. As I said, you've got a situation where the redundancy is seen as legitimate. So there's no issue around the genuineness of the redundancy. Where they fell down, unfortunately, the employer fell down, was actually the contract itself. Now, the contract, as usual, for a person who's been there for such a long period of time, there's multiple contracts, right? You've got the original contract, and there's new contracts all along. But there's a contract back in 2018 where the employee gets a new contract, and the contract says in the termination period by giving blank months written notice. Now, obviously, Leanne, this is probably a template contract, rolled out to all the senior executives. However, someone didn't fill in that blank space. And that becomes a real problem because now it opens up the arguments for what we call reasonable notice, and it doesn't just go to the Fair Work Act and you just get the minimum national employment standards. The key word is that's minimum notice period.
Correct.
What we're talking about here is for someone with that seniority, that type of salary, and of course the difficulties they're going to have finding a new role. It's just natural. It is what it is.
Yep.
Then the courts will look at what we call reasonable notice. And the key part there, Leanne, is reasonable notice is quite a long bow. So a lot of cases, all the cases around reasonable notice could be anywhere between 3 months to 24 months. Like that's how large it can be. And therefore, that's why we have this, even though failed job protection application, more than $170,000 payment still.
Now, when you speak about it could be 3 months, it could be up to 24 months. What could be the deciding factors when it comes to what that could look like in a case?
So there's a couple of deciding factors. So the very first one is that there's ambiguity around the notice period. That's the very first thing. So think of, in this case, a contract that wasn't drafted properly, okay? A contract that doesn't exist, a written contract that doesn't exist, so verbal, okay? So those who say, well, we don't need it, it's not worth the paper it's written on. Well, okay, I get the arguments for it, but the arguments for a written contract, it sets out the terms and conditions unequivocally. So, for example, in particular, for this scenario, we know what the notice period is going to be, even though they're a senior person.
Yeah.
Okay. And the other parts that will play a part is the person's seniority, person's age, whether the difficulties they will have to find a similar role in the market. Now, you and I both know, Leanne, people at the senior level, it takes time, exactly, but it takes time for them to go from one place to another place. So right there and then, you already know why the courts are willing to pay more in terms of reasonable notice. So they're the big ones that sort of play a big part in terms of what the reasonable notice is going to be, whether it's going to be bigger or relatively smaller.
Okay. So as you say, you mentioned that some people say that a contract's not worth the paper it's written on, but obviously that it is something that is required. It's part of the process. When we talk about a strong employment contract, what are the key things that should be in there or need to be checked?
So to clarify, the very first thing, in Australia, it is not required. You don't require a written employment contract, but we really should have one.
Mm.
And that's just for clarity in terms. If you think about any type of contract, the reason why we do it is for clarity. Yeah. Yes, where for pay, for job description, whatever it might be, but also when things go wrong, termination period.
Mm.
So that sort of also feeds into, to answer the second part of your question, which is what should we be looking at. So one, for example, is that notice period. Okay, so not just relying upon the NES. If you want to, you can say, as per the National Employment Standards, if that's what you wish to do, of course. Senior positions, it's likely going to be something like 3 months notice or 6 months notice, because that goes both ways.
Yeah.
Right? Both ways. And with more senior contracts, you're going to have provisions around guarding leave or suspensions or something like that as well. Intellectual property is going to be a big one. Return and use of confidential information, okay, especially at the end of termination. And if you think about, yes, I understand information is more freely available, but there are quite nuanced information that can be quite valuable for, in particular, an organisation who has a long-standing senior person leaving.
Yep.
Okay, so that's going to be key. Other key provisions, of course, are your basics: pay, bonuses. Other bonuses going to be discretionary or not discretionary. Like, you need to have those, understand those provisions. Things like in terms of the role. Okay, so what is actually the role? Does it actually reflect what they're actually going to be doing, or is it just a generic thing that's been put together? That can cause some problems too.
Yep.
So yeah, they're probably the main ones. But in terms of what we're talking about particularly, you really need to look at that termination clause and the notice clause in particular.
Okay, fair enough. So if you were to, and obviously you are talking to a lot of HR professionals and people leaders that will be watching this, but if you were to sort of say to them, what do they really need to pay close attention to when they are, from this case, that they should be looking at in terms of their contracts? What are they, if they had to go back to their contracts now, where should they go?
Okay, there's a couple of events that I want every HR lead or anyone in the HR team to think about these situations. Long-term staff member, so maybe you can't find the original employment contract. That happens quite a lot. Okay, now we've got digitized age. Maybe you can, but can't find it. What actually are the terms? Now, I suspect. No, I'm going to say assume. I'd assume it's changed since then. Yeah, I'd say the terms and conditions have changed since then. Has that been reflected? Now, if it has been reflected, maybe by way of variation, what are the differences? Okay, so other than what the variations for, probably like a promotion or a salary change, for example, what else has been changed? Okay, so that's where you might see some discrepancies around, for example, notice. So for HR professionals, those types of events. Another event that occurs if there's a merger or acquisition, anything like that. There's a change. Okay, so firstly, the contracts of your current staff, and then the contracts of any new staff that are coming over. Okay, so that sometimes will be checked during due diligence, and lawyers might check that, but sometimes it's not, and so you want to have a look at those contracts and see if they're in order, and if you need to issue fresh variations. Yeah. So that's another one. Another one is utilizing template contracts, but and it might be say drafted by myself at South Geldard, right?
Yep.
Give it to you, tied up a nice little bow. Here's a template contract. Here's the instructions. Now, it might be there's been some changes since then, change of staff, change of HR teams, whatever it might be. But the contract's been utilized, and here's the key point, but it has been amended every now and again. People have amended it, they want to change someone doesn't want to agree to a restraint clause, someone doesn't want to agree to a confidentiality clause, but somehow it's found its way into that template. So what I've drafted originally is no longer the same, or there's huge differentiations. Now that's quite normal, but you need to check that going forward to see where your risk points are. Some of it may not be, some might just be it's not really applicable.
Yep.
Okay, so that's true, but some of it actually might have a huge issue that you need to overcome, or obstacle you might have to overcome. So as an example, like this Lord case, it might be that, I was going to fill in the notice period later on, but just didn't get around to doing it.
Yeah. So if we go back to from the case perspective,
Yep.
If HR has that gut feel that they go, oh, we might be missing something, and looking at that case, if something had to go to either Fair Work or a general protections claim, based on the case and what the outcome has been, where would the court scrutinise the contract first? What are the key things they would be looking for at a glance to see if it's there or not there?
I suppose to answer your question, you will have experienced huge pedigree of tribunal members, okay, and judges. They will, in terms of the scrutiny of your contracts, they understand where the weaknesses are going to be. And they will go, if it's a termination case, they will look at the termination clause.
Yeah.
Okay. If it is a case around underpayment of wages, they'll look at your payment clauses. Now, if they're drafted in a way that doesn't really reflect reality, then you're going to have a problem. You're always going to have a problem if the contract doesn't actually reflect the reality of the situation. So the answer is, it'd be very easy for them to discern what clauses they need to look at. But it's going to be mainly to do with that case. So let's say job protections or anything to do with termination, they're going to look at your termination clause and they're going to look at your notice clause. Like that's very much so. Yeah.
Okay. So if you were to give HR 2 tips today based on the case, the outcome, and what we've discussed, what would the first 2 things you'd tell them to do?
Okay. So the first one is check your whatever template contract you're using. So you should have a couple of different ones. So one will be essentially for normal, non-award full-time staff or part-time staff. You could have one for award employees, depending on your mix of staff, but what are employees. You'll have one for, say, either senior management, something like that, or maybe team leaders. You'll have one for the executives, all right? Those are going to be different. Now, you might have another one for casuals, casual staff, casual contract, okay? And then maybe one more, it might be like a technical one. So let's say you're in an accounting firm. So maybe you might have a very technical accounting specific contract, okay, which might have some specifics in there. But generally, you're going to have, let's say, 4 or 5 different types of contracts that you should have. Now, you should be checking those and those templates, and make sure there are certain provisions are in there. So your termination clause, your notice clause, your bonus clauses, your confidentiality clauses, your hours of work, your pay, your job descriptions, like all those are there.
Yeah.
Okay. Now the next part is how they drafted. Are they drafted okay? Now, for anyone in the senior HR role, I think most of you can figure out what that is. For those who are maybe in a standalone role or more in a junior HR role, it might be a little bit more difficult. So I'm happy to discuss with anyone who would like to give me a call or email me or message me on LinkedIn, whatever way you want. I can then have a chat to you about that. The other one I'd say, Leanne, if you just divulge for just one moment for one more, a little extra tip, I would say when there's an event, some type of massive event, huge hiring of staff, huge restructures, merger, acquisition. You might have two companies running parallel for a long time, and then for some reason it's come together. Using contractors instead of employees, using employees instead of contractors. Like any of these types of workplace changes, anything relatively major, there's a lot of other stuff to check, don't get me wrong. But in terms of contracts, check your contracts, and that's a good time to say, well, do we need to issue fresh variations? Do we need to look, or do we need to, the contracts are so old, look at just issue contracts.
Yeah.
And on that part as well, any staff members who've been there for a long period of time, okay, do we actually have their contract? Do we actually know? Is that the latest one? And then do we need to actually issue a new one? The answer is usually about 95% of the time is going to be yes. We'll probably have to issue one, but do it. Because it won't be much different to what they're already on. Like what they're already on, it's just a reflection really of what they're already on. There's nothing sinister usually. It's just going to be what they're already on.
Okay, amazing. So obviously it's important to, put the contracts together correctly, do your homework, make sure it's set up correctly, review it and update the contracts as when you need it. Would you say that it would be valuable for someone in HR, whether they're junior or even senior and they've put contracts together for years, to still get a little bit of legal advice or guidance or review, just to make sure that those, that all the boxes are ticked, those risks are mitigated, that everything complies?
Leanne, I'd always say they should always get legal advice, and they should always get legal advice from Jonathan Mamaril at South Geldard Lawyers. That's what I should say. No, look, putting jokes aside, to answer your question, Leanne, yes. You should get advice. Now, if you're in a standalone position, you really should. Just do it. You should, at the very least, have someone look at it. Have a lawyer look at it, and that really look at it and go here, that because they usually won't be able to pinpoint 2 or 3 weak points in the contract, most likely. Okay. For those who are more, say, bigger teams, okay, you might have more freedom. You might have an in-house lawyer or whoever it might be. Great, do that. Okay. If you're in a smaller business, you need to.
Yeah.
You need to. Like, look, you can get away with, putting something together for a very short period of time, but eventually it will catch up. And when it comes to senior staff and high growth businesses, look, you need to get that in order. You can push the can down the road only so far, but please don't push the can down the road too far, because the reality is that when there's a complaint, when there's an application, anything really, one of the first questions that a lawyer is going to ask you is, where's an employment contract?
And what I've found was a lot of organizations, and I've been out to a few recently, where they sort of go, oh, we've got our contracts, it's all done online now, but we've still got people that have been with long tenure that have,
Yes.
There's a cabinet over there. We need to put that onto the system. And I'm like, so it's still manual, it's still sitting in a drawer. But those contracts, that they're sitting there and they're still manual, and you've gone, you started automating it from 2018, it would definitely be advisable to get that done.
Yeah, just update it. And then if you need to issue a variation or a new contract, just do it.
Correct.
Okay. So yeah, I get it. There's way more, dare I say, Leanne, sexy stuff to do in HR. I totally get it, right? There's super exciting stuff getting done everywhere, right? Lots of people talking about lots of different things, but just think about this, that total, and there's loads of, Lord is not one of these crazy case. No, there's loads of the reasonable notice case, loads of them, Leanne.
Correct.
Many. So it's not a one-off thing. You need to be on top of that. And is it difficult to get on top of? Not necessarily, but is it a bit of a slog? Sure. Okay. But dare I say it, if it really is, hit it off to your employment lawyer.
Yeah.
Hit it off to me. Hit it off to me if you like, and we'll have a look at and review. That's really just do that.
Yeah.
And that way it gets reviewed. It's up to date. You'll be able to tell generally. That sounds fine. Or, there's a few holes we've got in here. You should be able to tell generally by reading it. Off you go, get it reviewed, get it done, and then issue it if you need to.
Correct.
Yeah?
Correct. My philosophy is always short-term pain, long-term gain. So it's painful to get it all done now, but in the long run, it mitigates the risk. So
yeah, there's no real way. These cases really tell us if you do some of these basics right, if you can get a little bit of a budget to do that, just do it. Just do it and get it done, and you will you can actually see the commercial value in preventing that type of risk. Like that's a even that's a great pitch to whoever you're trying to pitch that to. Look at this case. We don't want to be in that situation. Let's just review it. Let's spend some money, bit of a budget. Let's get it reviewed and let's get it done.
Fantastic. Well, Jonathan, thank you so much for joining us today and for sharing the recent case and the findings with us. I think it is important for HR professionals to be informed, not only in relation to the case details, but the takeaway at the end of the same situation as well. So thank you very much. And if you are looking to grow your HR career or build your teams in 2026, People to People are here to help. Whether you're searching for your next opportunity or need help finding the right talent for your business, our leading recruitment experts have you covered. Get in touch with me, Leanne Lazarus, via the details on the screen below, or connect via LinkedIn. You can also visit our peopletopeople.com.au website or call us on 1300 121 727. Thank you for today and for joining us, and I hope you found it valuable. We look forward to seeing you at the next session.